Thank you, Mr. Speaker, sir, and honorable senators. For record purposes, my name is Mr. Ndubi. Mr. Speaker, sir, in determining this preliminary objection by the governor's side, we urge this Senate to be guided by the elements of a preliminary objection as espoused in the most celebrated case of Mukisa Biscuit. Mr. Speaker, you will agree with us that this particular preliminary objection fails all the three tests that was set out in that very old case. First of all, Mr. Speaker, sir, a preliminary objection is supposed to be purely on a question of law. Mr. Speaker, wherever there are questions of facts to be interrogated, then a preliminary objection ought to fail, as is the case before the Senate. Mr. Speaker, there is a contestation as to the exact number of the MCAs in Nyamira as at 25th November 2025, when this impeachment motion was taken. On the governor's side, they are contending that the MCAs in Nyamira were 35 in number. On the assembly side, we are contending that the total number of MCAs were 32 in number. Therefore, Mr. Speaker, there is a contested question of fact, even on the baseline, on the total number of MCAs that were present in Nyamira County Assembly, as that 20 preliminary objection does not meet the second element in the Mukisa Biscuit, is that a preliminary objection is raised and argued on the assumption that all the facts that have been raised by the other side are correct. Mr. Speaker, the governor has filed an affidavit together with his witnesses. This therefore means he is contesting the factual issues that have been raised by the county assembly. To that extent, Mr. Speaker, the matter has to go for full trial so that the senators can make their own independent determination on the factual issues that are being contested. Mr. Speaker, in the Kericho 1 impeachment, there was general consensus, both by the governor's side and the assembly, that the total number of MCAs were 47 and that those who voted were 31. So what was left for the Senate was to determine the threshold, whether it is 31 or 32. And that impeachment collapsed at that juncture. But in Kericho 2, there were contested factual issues, and that is why the matter had to go for full trial, and then eventually the senators had to rule on the issue of the threshold. Mr. Speaker, it is our submission that the position in Kericho impeachment 2 is the one that is obtaining in the present impeachment proceedings. There are highly contested issues of fact which cannot be determined summarily at this preliminary point. Very finally, on the third limb as to why this particular PO ought to collapse, Mr. Speaker, a preliminary objection ought not to be raised where issues of discretion are to be determined. Mr. Speaker, sir, the Nyamira County Assembly standing orders, especially standing order number 1, vests power upon the Speaker to exercise discretion and to rule on procedural aspects which have not been expressly provided for in the standing orders. To this extent, Mr. Speaker, to the extent that the governor's side is challenging the Speaker's exercise of his discretion to allow voting by proxy, the preliminary objection ought to collapse on that ground. Mr. Speaker, counsel for the governor has indicated that these particular 4 MCAs never delegated their power to vote. On our end, it is our case that they did delegate. Sincerely speaking, Mr. Speaker, at this juncture, how can a tribunal or a Senate sitting at this juncture, how can it believe the governor's side and fail to believe our side merely because you are being told affidavits have been filed? Mr. Speaker, if we are allowed to proceed for full trial, we will bring for you a phone where this particular one of the MCAs did send a letter on WhatsApp. We will provide the phone in its original form. We will also provide email correspondence by these particular MCAs who are alleging that they never allowed to be voted for by way of proxy. Mr. Speaker, under the doctrine of silence of laws, where an act of parliament is silent on a particular item, then generally that particular act of parliament does not provide for a certain action, and at the same time, it does not prohibit a certain action. To the extent that the Nyamira County Assembly standing orders are silent on the aspect of proxy voting, they do not prohibit and neither they do not provide for. So the general provision of law is that act of parliament is silent on any particular item, that particular action is allowed. It is therefore our case, Mr. Speaker, that voting by proxy is allowed under the Nyamira County Assembly standing orders. Very finally, Mr. Speaker, a calculation of 2/3 of 32 translates to 71.875. It is our case that the 2/3 threshold was not just met, it was in fact surpassed. This, Mr. Speaker, we can only demonstrate once we proceed for full trial. On the second limb, Mr. Speaker, of the issue of summoning the clerk and the Speaker of the Nyamira County Assembly, we pray if our colleague can drop that particular request. We do undertake to avail one witness, the one who was given the 4 documents. He will avail the documents, he will also avail his mobile phone, and he will also avail the email to which this particular document was sent to him. Mr. Speaker, sir, we do pray that you dismiss this particular preliminary objection, allow this matter to proceed for full trial so that the whole world can be able to see the atrocities that have been committed on the people of Nyamira County by His Excellency the Governor, Amos Kimomi Nyaribo. Mr. Speaker, sir, we humbly pray that you dismiss this preliminary objection in the alternative, determine on the PO as their first issue. We humbly submit. Thank you.
Now, Honorable Senators, pursuant to Standing Order 34 2A, I will allow later interruption of the proceeding.